This matter is the City of Hudson versus Darren and Amy Cooper. Both parties will have 15 minutes to present oral argument. The appellant will proceed first and may reserve up to 5 minutes for rebuttal to be able to respond to the City of Hudson. I'll be keeping the time, and so if you wish to reserve any time to respond to what the City of Hudson says, please let me know at the beginning. We have read the briefs of both sides, and so we're ready to proceed. Is it Mr. Cooper?
Yes.
Mr. Cooper, please come up to the podium.
You can tell like maybe 5 minutes up towards the end. I'll probably
Yes.
take too much time on this, I don't believe.
Okay.
I'm in 5 minutes, so.
Yes.
Okay, good afternoon, everyone. Your Honor, also Ms. Greenleaf, I think Ms. Greenleaf, she's been professional in speaking with me on the phone, so I definitely appreciate that. That being said, well, my wife Amy did not be here today, but I'm here, Darren Cooper, to speak about the appellants. We requested the court to reverse the trial court's decision and dismiss the matter originally brought against us. That's why we're here today, to discuss that. Regarding the brief that was filed by City of Hudson, the Regional Income Tax Agency filed on October 21st, 2015, I was going to briefly discuss some things that I highlighted. On page 2 of that brief that was filed, issue presented for review, it states Darren Cooper and Amy Cooper, the Coopers in parentheses, failed to appear or otherwise defend against the complaint filed by the City of Hudson, Ohio, the city. That was the original. And I have with me today, that was on that court date in question. That court date was January 14th of 2015, the one you're discussing or mentioning in that brief. I have some information here just to provide to the court or let the court know. On January 14th, 2015 and January 15th, 2015, I'm involved with, well, CWA 4526. It was our negotiations. So I'm involved in negotiations, and at that point, what that means, I'm pretty tied up from 8 a.m. to 5 p.m., 7 p.m., 8 p.m., it just depends on the outcome of the day. I guess at that point in time, I attempted to contact the original court, still municipal court, and at that time, I did not have enough time to, I guess, have it continued. But I do have that paperwork here from my schedule from January 14, 2015.
Was anything filed, Mr. Cooper, with the court seeking a continuance or asking for more time?
Not with the Stowe Municipal Court, no.
Okay. And I ask that because even though you are sharing that information with the court, as a reviewing court, we're only able to review what's in the record before us. So whatever was filed in the court and came over from Stowe Municipal Court, our review is limited
Okay.
to that.
All right. Okay.
Go ahead.
And on page 3 of that same brief, under the statement of the case, it states, well, again, we just talked about that. On January 14th, the matter came before the Stowe Municipal Court small claims hearing that the City of Hudson against the Coopers that we failed to plead or otherwise defend against the complaint. And again, that's one reason we did not do it for that. And also states that the Coopers now attend on appeal that an underlying judgment was improper. But we do, again, feel that the judgment was improper because, as it states here on page 4, the next paragraph, first paragraph, the Coopers, however, failed to make several payments, including March, April, June, and November 2014. In our brief that we filed on September 8, 2015, I stated, just paraphrasing, but I stated that we're not perfect. We made most of our payments, but we did miss payments. And I explained that to Ms. Greenleaf and also explained to my representative at the Regional Income Tax Agency, RITA, RITA. I explained to them that for the most part we had made our payments as best we could, but again, we did miss payments. And I did explain that to them, and that's why we've always been set up on a payment plan, and we tried to abide by the payment plan, but again, that was not perfect. It wasn't made 100%.
So as I understand, Mr. Cooper, from reading the briefs, there was a payment plan set up initially that required $90 per month to go toward the city taxes, correct?
Correct.
And then there came a time when the city notified you and your wife that because several payments had been missed, that plan was going to be tossed out, but you were invited to set up another plan which had a lower payment.
Yes, they asked me what the payment we could make, and we said, well, let's try 75, and if we can add additional more per month, we will go from there.
Okay.
Yes.
And so you began making those payments at $75 a month, and those payments were made without fail. Is that correct? Or did you fail some of those?
Yes, I have some dates that I can go over. I mean, without fail, I mean, they weren't perfect. We did not make 100% of the payments, but we made a large amount of payments. I have the.
And I think you put those in your.
Okay, all right, okay.
You put those in.
Okay.
The city says that they, that at the time that they notified you that the payment plan on the $90 was not working out, that they also notified you, I believe they said that they had the right to go forward with filing a complaint. Do you remember receiving any kind of notice like that?
Yes, and that being said, to answer your question, and speaking with Ms. Greenleaf, that was one of the questions, because we received so much information or mail from RITA, the Regional Income Tax Agency, and that was something discussed with Ms. Greenleaf. There's so much paperwork, and maybe that documentation, maybe we got miscommunication, I'm not sure. We put the words miscommunication in our brief, but maybe got misplaced, I'm not sure. But I'm not really remembering about them probably want to go forward with the lawsuit or judgment against us, because I've been in contact with so many different individuals, including Ms. Greenleaf and my representative at RITA also.
Okay, go ahead.
And with the additional dates that I put into our brief, I started with 2015, in August 2015, because that's where it kind of ends in the brief. For August 15, 2015, we made a $75 payment. August 17, 2015, we made a $75 payment. September 28th, 2015, we made a $75 payment. In October of 2015, we did not make a payment. November 23rd, 2015, we made a $75 payment. In December of 2015, we did not make a payment. And beginning of 2016, in January this year, on January 4th, we made a $150 payment. And February 12th of 2016, we made a $75 payment. And again, I guess the main issue for my wife and I, Darren, my wife and I is, I thought at best we had good communication going on with RITA, the Regional Income Tax Agency. We were still unsure, clarification why the judgment was filed, because we felt that, again, I put in a brief that we were making payments. And I've quoted some payments and I quoted them in the brief as well. Percentage, 80% of the payments were made on time, 85, I'm sure the percentage, but we were making the payments and we accepted the responsibility. We were in contact with Ms. Greenleaf at least two times, but my representative at RITA, and we felt everything was fine between us with our relationship, because we've been working with RITA for quite some years now. So, but we feel now that it's best to pay this bill up front when it comes out each year than going through the payment plan process, because there's so much mail and information going back and forth to the home and getting misplaced, not receiving it late, whatever the case might be. So that's why we came today to say that that's why we felt it should have been reversed, because it was filed. We felt it should not have been filed at the initial court, but also that's why we appealed it with the 9th District Court of Appeals today. So.
Did you want to reserve the rest of your time
Yes.
in the event that
Yes.
you want to say something? Okay. Thank you.
Do I get to ask how much time is it?
You'll have 5 minutes
Okay.
remaining. Yes, ma'am.
Good afternoon. May I please report, Mr. Cooper? My name is Amber Greenleaf. I represent the city of Hudson in the appeal currently pending before you. As provided in the briefs, the underlying action relates to municipal income tax owed to the city of Hudson by the Coopers for tax years 2012 and 2013, and relates to a judgment that was awarded to the city and against the Coopers for both years for balances equaling $834.30. Although the Coopers state they believe the judgment was premature and unnecessary, I would submit to this court that neither is a legal basis for overturning the underlying judgment. The judgment was proper procedurally according to Civil Rule 55 and was substantively proper in that there was sufficient evidence introduced at the trial court level at the small claims hearing supporting the request for judgment. With regard to Civil Rule 55, as Mr. Cooper mentioned, judgment was awarded based on the fact that they had not appeared. He admits that he did not appear, nor was there any filing for a continuance or any answer filed in that matter, although they had been properly served by a certified mail and also received notice of the date and time of the small claims hearing. Relating to the sufficiency of the evidence, the city introduced a detailed breakdown of the tax penalty and interest for tax year 12 and 13. It specifically spells out the balance for each relating to the wage information that is provided by the Coopers.
There was no,
I'm sorry?
It does not appear to be any challenge to the amount by the Coopers, correct?
Correct. There is no dispute to the sum owed. Based on the evidence presented, the magistrate did submit a decision, a finding for the city of Hudson for the balance. That was not objected to within the 14 days as provided by the civil rules from the Coopers. And considering that there was no objection filed, the trial court did adopt that magistrate's decision. Finally, the Coopers' argument that because they were on a payment plan with the city, the action should not have been filed or the judgment awarded. Specifically with regard to the payment plan, the initial payment plan was the $90. There came a point in time when the Coopers had missed about approximately 4 payments. This was throughout that year. And 2 separate notices went out in writing to the Coopers indicating you're in default, you're required to become current on your payment plan, and in the event that that doesn't happen, it can move to our legal department for further legal action. Nothing was received. A couple $90 payments did continue to come in, but the account was not brought current. It did move to the legal department in the agency. At that point in time, the Coopers did contact the agency to talk about setting up another payment plan, which is the $75 payment plan. During that phone conversation, the Coopers were informed that the case was being prepared for legal action, that there would be a hearing in the event of the filing of the action, and that a judgment would be requested at the small claims hearing.
So that was a phone conversation, not a written
Correct,
notice.
correct.
And how's that in the record before us?
It's not, Your Honor. I apologize. With regard to the payment plan, the $75 payment plan, it was started approximately 1 or 2 months before the action had been filed. At this point, they have been consistent with their $75 payments. They did miss one, and they do owe for this month, so there are 2 currently pending. I would still submit that, considering the fact that they were delinquent on the prior payment plan and had defaulted and were notified of that fact, that the city was faced with the option of what do we do next to protect that balance, the collectability of that balance. So the city did decide to move forward with legal action. The action was filed, not only to protect that balance and the collectability, but also to offer the city additional options for recovering that balance, whether it was garnishments or bank attachments. While I understand the Cooper's frustration with the current situation, the balance was reduced to judgment. We are still attempting to resolve that matter with them, and upon receipt of the balance payment in full, it will be satisfied the judgment. If the payment plan had been kept current, it would not have gotten to the point of litigation unless, of course, there was a statute issue and we were running up against the statute of limitations, which was not the case, but because of the default, we did move forward. The payment plan is generally a courtesy to taxpayers, in this case the Coopers, to attempt to resolve the outstanding balances without having the litigation, but unfortunately, again, due to the default, it was necessary to move forward with the action. I would submit that the Coopers have not presented any legal basis, statutory, case law, ordinance, or otherwise, that would have prevented the city from moving forward with the civil action in this matter and obtaining and requesting the judgment. So I would ask that the Cooper's assignment of error be overruled and that the judgment be affirmed.
Thank you. Thank you very much. Mr. Cooper, you have some time remaining. If you have any further information that you'd like to share based on what Ms. Green shared.
Yes.
Yes, please. You have about 5 minutes.
Yes, I want to let the court know that the appellants do have a right to the appeal process. That's why we are here today. I do know, I did hear Ms. Greenleaf quote Civil Rule 55. She just quoted regarding the process, the legal proceedings. Again, the trial court did state, we have a copy here, we mentioned about the trial court in Stowe, say that we were allowed to file an appeal 30 days from that particular date, and that's what we did, and that's why I'm here today regarding that. Ms. Greenleaf mentioned that no dispute to the, we did not dispute the amount to the specified, RETA, Regional Income Tax Agency's number that stated that we owe, because we, again, accept the responsibility for that payment. Again, we were just unsure, clarification again why we were here, because we felt we had a good relationship and communication with RETA, the Regional Income Tax Agency. Regarding the default, speaking with, I had his name at the desk, Richard, B-A-L-D-Y, Balyega. I spoke to Mr. Richard quite a few times on the phone, and when I speak to Mr. Richard, default, Mr. Cooper, I received, Ms. Richard, I received a letter in the mail, the default, that means you can bring your information current. We make a payment, and that's pretty much where that goes at that point, because I have a letter from Rita right there regarding the default paperwork and our schedule plans and so forth. And also have documentation here, it says tax year now, the balance due is $0. This is as of February 15, 2016. In 2013, the balance is $424.79 on this paper. We did make a payment, but as of this paper right here from Rita, it says Rita e-payments. And also, Ms. Greenleaf has stated about the information about being a judgment against the appellants was not in the brief, but it was made through a telephone call. Again, we have received so many documents from Rita and information being received from Rita, and that's what I mentioned when I stood the first time. That's the question that I had. The information about receiving this documentation in mail about having a judgment filed against us, we're going to have to go to court, there's going to be a lien, garnishment, so forth. She said it was not in the brief, and I did not have any documentation about that. Again, that's why we were perplexed, confused about why we had to go through this process in the first place, because we've been quite honest, we've been on a payment plan with Rita for quite a few years.
It's my understanding that they were seeking taxes that were owed from 2012 and 2013. That's what this money is
Correct.
for.
Yes.
And that they only have, according to their brief, they said they only have 3 years to collect that money. Otherwise, they can't come and get it anymore.
Yes, correct.
So that's my understanding. That's why they decided to pursue the court action so that they could secure that judgment.
Correct, and that's a great point. That's the issue that myself and Ms. Greenleaf had on the telephone. She stated, Mr. Cooper, do you know you have 3 years from that date to pay for these taxes? We live in Maple Heights, City of Lyndhurst, and now City of Hudson. I have not received or do not know and did not know that law, that proceeding, until Ms. Greenleaf told me that and gave me that information on the telephone. We have 3 years to pay off a bill. I'm like, honestly, I don't know where that came from. I don't know how that process works, but that's why we're here now, because we did not have that information. You have 3 years to pay off a debt. 1 could have been paid off, but 2, we have no documentation about that. 3, we didn't know about it.
But I don't think that that's what Judge Schaefer is saying that you have 3 years, it means that the city, if they don't collect within 3 years, they're prohibited. Not that that means that you can just spread it out, necessarily for that amount of time. And I think that may be part of the confusion.
And if I could clarify, so that 3 years, that if not paid within 3 years, they're allowed to file a judgment lien and garnish wages? Or-
They can't come after you. If you don't pay it within the 3 years, they can't come after you for the money anymore.
Okay,
So
that's
that
what,
would
okay.
explain the reason for the filing the complaint, even though you were still making those payments, that if they don't do it in a certain time frame, then they're precluded from doing it.
And again, that's clearing up a lot of information while we're here today. But again, we did not have that information in writing. Again, we accept the responsibility because it is our bill, our debt, and we need to pay. But we did not have that information and that knowledge and that legal process to take care of this before having to come to court today. So that's why we are here, about the 3-year period for them to collect their money. She stated that agency wants to protect their monies. We understand that. That's why we're accepting responsibility. And again, I already mentioned we live in Maple, Hazelton, and now Hudson. We do not have their information, but again, we're praying for the court to reverse the decision in the appellant's favor.
Thank you, Mr. Cooper. Thank you, Ms. Green, both of you. I'm sure this is not a very easy litigation for either side, but I appreciate the professionalism on both sides. We'll take the matter under advisement. We will issue an opinion after we've reviewed all the law, and it will be sent to both sides, and it will also be posted on the Supreme Court website. Thank you. Have a good day.
You too.